Okay, welcome back. We'll continue this video tutorial, starting with direct examination. We'll hopefully get through cross-examination as well as the rule of evidence, but let's see how far we get, or how long this video will take, and maybe we'll chop it up into another video or so. Let's see how we go. Okay, so direct examination. What is it, and what is it designed to do? Well, when we're doing a direct examination, we're questioning our own witnesses, right? So these are going to be the witnesses that your side has called. So they're there to present your side of the case, right? They're there to give favorable testimony. So the questions are designed to get the witness to tell a story, reciting what he or she saw, or what they heard, what they experienced, or what they knew about the case. So the questions must only ask for facts, not for opinions, unless you're questioning an expert witness. Expert witnesses can give opinions, but general witnesses, no, you can only ask them about particular facts. So when the direct examination is completed, an attorney for the other side then asks questions to show weaknesses in that witness's testimony, and this is what's known as cross-examination, which we'll discuss either later in this video or in a different one. So the objective of direct examination, again, is to obtain information from favorable witnesses that you call in order to prove the facts of your case. So before you write your questions for your witnesses, it might be a good idea to list the objectives that you wish to obtain from each of your witnesses. Right? So make sure that you have a clear purpose for each one of your witnesses. What is it that they're going to add in terms of their testimony? What information is it that you want them to provide on the witness stand? So once you have a list of those objectives for each of your witnesses, you will have a much easier time drafting questions that will help you meet those objectives. You want to make at least one major point for your case for each witness. You'll see that there's going to be way more than one major point for the witnesses that we call. There's a lot of evidence in this case, and not a whole lot of witnesses, so these witnesses are going to be pumping out a bunch of information. So witnesses, again, may not give opinions or conclusions or speculations unless they're deemed an expert. So they can only tell you what they know to be true, or if they're an eyewitness, what they experienced, what they perceived. If physical evidence is to be produced, such as a murder weapon, let's say, it must have a witness to identify it and to testify to its relevancy. So the way that we introduce all evidence, including physical evidence, is through our witnesses, through testimony. Okay, so keep that in mind. If there's physical evidence that you want to discuss, think about which one of your witnesses would be the person to ask questions about that. That person is essentially going to be how you introduce this physical evidence into evidence, how you get it into the case, into the trial. So in terms of prepping your witnesses, preparing. You want to, for each witness, isolate exactly what information each witness can contribute to proving your case, and prepare a series of questions that are designed to obtain that information. You want to try to limit the number of questions that you ask. So these questions should be pretty succinct. They should get right to the point. Be sure all items you need to prove your case will be presented through your witnesses. Make sure that you have a witness to speak to each one of the items in your case that you want the jury to hear. You want to avoid asking leading questions, so you will likely get a challenge from the opposing attorneys if you're asking a leading question. So no leading questions during direct examination. You also want to be able to think quickly if the witness gives you an unexpected answer. Hopefully you will be practicing with your witnesses, so there should be no surprises, but you never know. Sometimes they forget their testimony, or they answer in a way that doesn't sound right or doesn't come across right, and you need to be quick on your feet in order to turn that around. So be prepared for the unexpected, let's say. So how do you go about forming these questions? Well, you have to establish, quote unquote, your witness. So when you call a witness to the stand, the first type of questions that you're going to ask are questions that are going to establish who this person is. What's their name? What's their occupation? Some questions about their background. How long they've lived in a certain place, if that's relevant. If they're an expert, you would ask them about their qualifications. What qualifies them as being an expert, let's say. So that could be, where did they go to school? What's their job? Do they do their own research? How many publications do they have? Are they in peer-reviewed journals? So on and so forth, right? You also have to establish a quote-unquote foundation, right? So the court starts from scratch, essentially. The jury, definitely, they start from scratch. They have no idea who any of these people are, and they have no idea why you're calling them to the stand. So you have to establish who the person is, and also why are they here, right? Why are they testifying? Why did you call them to the stand? Your questions should be open-ended, so try not to ask yes or no type of questions. The questions should also follow a logical order, and each question should build on the other. Remember, you're using your witnesses to tell a story. So in order to follow a story, the timeline should make sense. So just keep this in mind in terms of when writing out your questions, but also when figuring out the order in which you want to call your witnesses. Remember, the goal here is to use your witnesses to tell a story. So you could make a quote-unquote train of questions to prove each issue or point that you are making, and be able to ask extra questions if necessary. So you will come up with some questions, and you might practice with your witnesses, but both you and your witness should be able to improvise if need be on the spot. Okay, so when it comes to your style of the attorney conducting the direct examination. The questions, again, should be designed to get witnesses to tell a story in a logical manner. So try to avoid lengthy or complicated questions. It's much better to ask multiple short but very clear type of questions rather than long, complicated questions. Remember that you can't use leading questions during direct examination. Also, uncontrolled narrative questions are not permissible. You can't say, so tell me what had happened, right? That would be a narrative. They might start going off on a tangent. You have to be more precise, right? So tell me what happened at this place on that day between these two people, right? You can't just give an open-ended question that lets people go off on anything, any story that they want to tell. You want to avoid multiple or repetitious questions because those are objectionable, meaning the other side will likely object. A common objection is objection asked and answered, meaning you already asked this question, they already answered it, move on, right? So you should also be prepared to rephrase your questions. So if there was a particular point that you wanted to get out of, say, a witness, and they didn't provide it to you in their answer, you might need to rephrase that question in a way to get to that piece of information without asking the same question again. Also, if you are leading the witness, that's also objectionable. The other side might say, objection, Your Honor, leading. You would need to rephrase the question in order for it to not be a leading question. Okay, so what the opposing attorney should be doing during cross-examination is listen very carefully to the questions that are being asked. So cross-examination is what the opposing attorney is going to do after direct examination is done. Cross-examination must be limited to the subjects that were discussed in direct examination. So if a topic was not mentioned in direct examination, then you can't ask about it on cross-examination. So pay attention to the questions that are being asked so you know what you can ask on cross-exam. Also, keep a listen out for violations of the rules of evidence and be prepared to make good objections to lines of questioning that's happening during direct examination. When it comes to witnesses, believability, aka credibility, is most important. So the witnesses should be prepared, be confident in their answers, and they should tell their stories clearly with as little hesitation as possible, because hesitation can create some doubt in jurors, and then they can start questioning the witnesses' believability. Okay, so let's see what else we got here. When it comes to redirect examination, so this is after you did your direct examination of the witness, then the opposing team did a cross-examination. You might have the opportunity to do a redirect examination. So when can you do a redirect examination? Well, if the witness's credibility has been attacked on cross-examination, attorney, you might wish to ask a few more questions, and you would do so or could do so by asking for permission from the judge. You say, Your Honor, permission to redirect the witness. So the questions that you ask on redirect examination should be limited to the damage that the attorney thinks was done by the opposing lawyer during that cross-examination. So the purpose of redirect is to kind of restore the witness's credibility. So restore any kind of damage that was done to their credibility during the cross-examination. So the type of questions that you ask, though, should be phrased to try to, again, rehabilitate or restore the witness's credibility. And if the redirect examination is permitted, then the cross-examining attorney will also be allowed to do a cross-examination. So be careful what you ask for, because if you want another opportunity to, or you want the opportunity to restore some of your witness's credibility on cross-exam, and you ask for a redirect in order to do that, well, then the opposing attorney gets another shot at damaging this person's credibility. So again, be careful with the redirect, because if you're allowed to redirect, then they're going to be allowed to cross-exam your witness. Okay, I'm going to show you a video here that is an example of some direct examination line of questioning.
Good afternoon. I'm Professor Dan Kaufman here for the MLS Network, and the next part of the trial that we'll be discussing today is the direct examination. The direct examination is the most important part of the trial as far as putting evidence on. This is the time where the plaintiff or the defendant has a chance to put on the evidence that they're going to use to prove the case, whether it's putting in pictures, documents, contracts, any type of exhibit use happens during direct. Now, direct is also the most dangerous part of the case for two reasons. Number one, if you fail to lay the elements of your case, if you fail to prove what you need to prove or put things into evidence that you need to put into evidence, your case is over effectively at the end of your case in chief or your part of the case. So if you don't do it during direct on your case, most likely the evidence will not come in and you can simply lose on a technicality. The second reason why the direct is the dangerous part of the case is it's also the number one time the jurors fall asleep. All joking aside, the jurors are just gone by the first 10-15 minutes of this exam because they're very elementary foundation questions that just bore the hell out of everybody. Especially you can have some doctors or forensic experts that take 3-4 hours. I mean, most of us can't listen for 3-4 minutes to something like that, let alone 3 or 4 hours. So during the direct, there's one crucial rule, and then we'll do a sample direct shortly. The one crucial rule for direct is that all questions have to be open-ended. In other words, you cannot lead the witness. You can't say the light was red, correct? You were there, right? You saw him hit him over the head, right? You have to ask things like, what happened? How did that happen? Then what happened? Explain this to us. Giving the witness a chance to talk. If you ask it the other way, which is called a leading question, that's subject to objection that will be sustained almost every time as objection leading. So we'll now move into a sample direct of how to handle a witness, laying the groundwork of who the witness is, what they saw, how they saw it, why they saw it. Their opinion in certain situations is also allowed, although usually only allowed in expert testimony. Good afternoon. Please state your name.
My name is Joel Magdovitz.
Mr. Magdovitz, where do you live?
I live in New York City.
And what do you do for a living?
I work for the city.
Where were you the night of March 14, 2009?
I was at a buddy, Brad Furman's house, and we were just watching a football game.
And who else was there with you?
My buddy, Sam.
And could you tell us what happened that night?
Well, we were sitting there, we were watching the football game, you know, as usual, and then all of a sudden, he my buddy Brad just got like really upset, and he hit him in the head with a football helmet.
What caused him to get upset?
Well, we were watching the game, and there was like a really big play, and then Sam started just kind of like getting into his face and kind of mocking him and telling him how his team's better than the other team, and Brad didn't like that, and he just whacked him upside the head with the football helmet.
I want to show you what's been marked as the state's Exhibit 1 for identification, and I'm going to hand this to you. Your Honor, may I please present this to the witness? Go ahead and take a look at that, and tell me if you recognize what I've given you.
Yeah, this is it's a helmet. Looks like the same helmet, and it has this marking Furman on the inside that is Brad's helmet.
Is that the helmet that Brad used when he struck Sam?
Yeah, this is the helmet.
And is it in the same condition that it was in the night that you saw Brad use it to strike Sam?
Yeah, for the most part, it looks pretty solid. So yeah, I would say this is it.
At this time, Your Honor, we'd like to move the helmet into evidence as State's Exhibit 1 for evidence purposes. Thank you, Your Honor. This is Professor Dan Kaufman. You're watching Mr. Law School, but you should be studying.
Okay, so that was an example of pretty basic, decent direct examination. I'll show you an example of another one, and she's actually really good in her line of questioning and the way that she's approaching her witness. I believe her witness in this next example is a victim or the family member of a victim. So you're going to see her try to humanize and personalize and sympathize with her witness.
Good morning. Would you please turn and introduce yourself to the jury?
Good morning. My name is Carissa Washington.
Miss Washington, how old are you?
29.
And would you tell the members of the jury why you're here today?
I'm here because 2 of my children were killed. They were taken from me.
Now, Miss Washington, before we get into all of the accident, I wanted to ask you a few questions about your children. How many did you have?
At the time of the accident, I had 6 children.
And how many do you have now?
I was pregnant at the time, so I have 5 now.
Okay. And Miss Washington, where do you and your children live?
It's not the best neighborhood. We don't really have that much, but my family was priceless. We had each other.
Miss Washington, did you ever have any problems with your children?
Just one time, DCF had to come out to the house, but that had nothing to do with me, and we fixed the problem immediately.
Well, that problem, would you mind telling the members of the jury a little bit about it?
My boyfriend at the time, he beat his kids, and I didn't know that. So once I found out, I kicked him out.
Okay. Now, Miss Washington, I know this is going to be difficult, but I want to talk with you about the day that your 2 children were killed. Would you tell the jury how the day started out for you?
The children had just gotten home from school. It was March 21st. I'll never forget it. It was a beautiful day outside, and they really wanted to go to the park. At first I said no, because it was getting a little bit cold. But Jordan insisted that he would watch his brothers and his sister, so I walked them over there.
You mentioned Jordan. Who is that, Miss Washington?
Jordan was my 14-year-old son.
Now, Miss Washington, why did you allow Jordan to go to the park with your other children?
He was so good with the other kids. He really liked being the big brother, and it taught him responsibility, so I mean, they deserved it. They were good kids. I wanted them to go outside and play.
Did you go with them to the park?
Oh, absolutely. I walked them across the street. I dropped them off at the park, which is also a community center, and I told them that I would be back to get them.
And when did you go back to get your children?
I noticed it was starting to get dark, so I walked outside, and then a neighbor ran up to me yelling, and I ran across the street, and that's when I saw Jordan lying on the ground, bleeding.
Now, Miss Washington, when you saw your child lying on the street bleeding, what did you do?
I knelt, I, I, I fell to my knees, and then I saw Ronald, my other son.
Now, Ronald, where was he?
He was also lying in this street, and he was lying there lifeless. He had already died.
Now, Miss Washington, I just want to back up for a moment. When you got to the street that day, did anyone tell you what happened?
People just said a car came out of nowhere, and that's all I remember.
Okay. Now, Miss Washington, did you ever find out who hit your children?
Yes, Rebecca Hartwell.
And how do you know that?
About a week later, her parents came to my house, and they told me. They tried to talk to me, but it was just too soon, and I wasn't feeling up to speaking with them.
Now, Miss Washington, you said that Rebecca Hartwell's parents came to your home. Did you ever hear from Rebecca Hartwell herself?
Not personally. I saw her on the news. She was reading an apology off a piece of paper. It wasn't much of an apology.
Miss Washington, did Miss Hartwell ever apologize to you personally?
No, she didn't. She killed my children, and she never personally apologized to me.
Thank you, Miss Washington. No further questions, Your Honor, at this time.
Okay, so you can see, pretty powerful direct testimony there, right? Okay, so we'll basically load up the slide that deals with cross-examination and rules of evidence, or you know what? I'm gonna make that into a separate video. Okay, so just look for that link. Okay, see ya.